Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone, and thanks for joining us. I'm Tiffany Thomas, one of the lawyers here at SpringLaw, and I'm here today with one of my colleagues, Eveline Hellinga, for our monthly Spring Forward webinar. If you're one of our existing clients, you already know that we are employment, labor, and contracts law firm. We're fully virtual, based here in Ontario. We do a webinar every third Wednesday of the month, and we cover different legal topics in each webinar. Throughout our time today, you can feel free to ask us any questions you do have using the chat function, and our team will send us the question. We always do our best to answer these questions throughout the webinar. The slides are actually in the handout tab today, so if you want to follow along, you can grab those and follow along. If you have any questions about our firm and you want to learn more about us, or if you're looking for some excellent resources on any of your burning questions about labor, employment, or contracts, please visit us at springlaw.ca. You're going to find our award-winning blog there, our monthly newsletter, and information about some of our innovative legal programming for employers, including our subscription programs and our Boss Law Bootcamp. On the next slide, you're going to see a lovely picture of Eveline and I, though these are your presenters for today, of course. Before we move on, we're going to take a brief moment to acknowledge that we are on the traditional territory of many nations, and that this territory is now home to many diverse First Nations, Inuit, and Métis people. And of course, it wouldn't be a legal presentation without some sort of disclaimer. So today is all about legal information, not legal advice, and we have a slide on the next slide of our detailed legal disclaimer, which you can read at your own pleasure. But again, the takeaway for today is that this is all legal information and not advice. So with that, let's talk about what we're here today to talk about. So we're going to talk about what is likely a very common occurrence in your workplace, employee absences. So employees, as you know, may require a medical leave of absence for various reasons, undergoing a medical procedure due to a medical incident or to manage any sort of illness. These late leaves can last anywhere from a few days to a few years. So today we're going to talk about your employer obligations with respect to these leaves and how to manage long-term leaves, including referencing some circumstances that may arise as a result of these leaves. I'm going to turn it over to Eveline to talk to us first about general leaves and the process of accommodation.
Thanks, Tiffany. So today, as Tiffany mentioned, we'll be talking about these complex statuses, focusing on employees who need to take a leave from work due to a disability or medical condition. So starting with the basics, where do employees' entitlements to medical leaves come from? There are a number of sources of law that provide for these kinds of medical leaves. We've outlined them on this slide here. You'll see the employment standards legislation is the basic one that almost everyone or most employers would know about. In the Employment Standards Act in Ontario, employees are entitled to 3 unpaid days of sick leave every year. And following the Employment Standards Act, there's a number of other sources of law that provide for sort of different variations of medical leaves. So under the Human Rights Code, which is something we're going to talk about at length today, employees are entitled to be accommodated to the point of undue hardship for disability-related medical restrictions and limitations. And sometimes that can look like a medical leave for a period of time. Then there's also specific protections for workers injured in the workplace, we won't get too deep into that here, but just know that workers' compensation legislation also provides for specific entitlements in those situations. And then there's the common law, which very generally provides that employees can't be unfairly disciplined or terminated for short-term absences that are outside of their control, which is typically the case when there's an illness or disability at play. And finally, as you probably know, an employment agreement or employment policies or employer policies can also dictate an employee's entitlements. So if you have paid sick leave in your workplace or personal days, that would provide an employee with an entitlement to those days according to your policies. And often employers will also have short-term disability leave or long-term disability leave benefits, and an employee's entitlements to leaves would also be dictated by those agreements and policies. So generally, an entitlement to medical leave means the employee's job is protected or kept for them while they're away on the leave, and they can't be disciplined or terminated for taking the leave. And then in those employment agreements or employer policies or specific legal sources, there might be other provisions like pay during that leave as well. Next, we'll talk a little bit about the basics of the employer's duty to accommodate. Excuse me. So what is the duty to accommodate? In Ontario, it's a legal duty that's imposed on employers under the Ontario Human Rights Code under sections 17 and 24. So typically, the duty to accommodate begins with a request from an employee or where the employer reasonably ought to know that an accommodation may be required. And that means, if it's reasonably apparent to an employer that the employee has a mental or a physical condition that's interfering with their job duties, the employer should investigate even if the employee hasn't requested an accommodation. So the employer should, have a tactful conversation with the employee to understand if there may be an accommodation required. And generally, the duty to accommodate requires some modification in the workplace. So that might look like a change of hours for the employee to accommodate medical appointments. It might be assignment to specific shifts, again, to accommodate appointments or other disability-related restrictions and limitations. It might be a change to the work assigned. It might be a change to work equipment that's being used in the workplace. It can be any number of things. It's really an individualized process and result. So I'm not going to go through the full legislative provision, but just so you know, you can find it in section 17 and also 24 of the Human Rights Code. You can look that up. It's available online, or you can refer to back to this slide. But importantly, an employee has a duty to accommodate to a point of undue hardship. So an employer is not required to accommodate, to provide whatever accommodation the employee is asking for at all times. There is a limitation, but it's a pretty high bar. So what is undue hardship under the Human Rights Code? It means the employee must be able to perform their core duties of the job with accommodation. And that accommodation an employer's ability to accommodate may be limited by health and safety considerations and cost considerations. So, the tribunal or a court would also consider outside sources of funding if that's relevant to your workplace. So what this means is if the accommodation requires the employee to put themselves or someone else at the workplace in a risky situation when it comes to health and safety, the employer is not required to sort of put forward that accommodation or facilitate that accommodation. And similarly, if it's simply prohibitively costly to undergo the accommodation that's required, an employer may have reached that threshold of undue hardship. The size of the organization matters. If you have a huge organization, you likely have more resources or infrastructure to be able to provide more sort of complex or costly accommodations than a very small employer. And when it comes to leaves, which is what we're talking about today, leaves are generally unpaid, and so typically, at least for short-term leaves, it's difficult for an employer to state that allowing the employee to take that leave constitutes undue hardship. We'll talk a little bit about more about that through the rest of this presentation. Key concepts in accommodation, which we've just covered briefly, are that accommodation is an individualized process. So just because one person required a leave for, say, 10 days, doesn't mean that can be your absolute threshold for all other employees when you're talking about or considering accommodations. It really is dependent on the employee, their medical restrictions and limitations, as well as the business's ability to accommodate at the point that it's being requested in terms of cost and health and safety considerations, as we just discussed. And unlike minimum standards, there's no arbitrary limit on the length of an employee's protected absence under the code. So it's all fact dependent. Next, we'll talk about asking for medical information when an employee needs an accommodation, and specifically when an employee needs an accommodation of an absence for a period of time. We could give a whole presentation on this topic. We advise on it regularly because appropriate requests for accommodation is also very fact specific, but typically where an employee asserts a workplace right to a medical where an employee asserts a workplace right related to a medical condition, for example, a right to take some time off of work, they're obligated to provide the employee with the medical information that's reasonably necessary to support that request and that exercise of that right. This is sometimes informed by statute. So in some jurisdictions, an employer is entitled to request medical documentation to support a sick leave after a certain number of days. In Ontario, the Employment Standards Act provides that the employer may require reasonable evidence of entitlement to the leave. So what's reasonable evidence? Typically, if it's just a couple days, like an employee is sick, they have the flu for a day or two, it's not reasonable to request a doctor's note to substantiate that absence. But if it starts to extend for a longer period of time, 3, 4, 5 days, that's when it becomes reasonable for an employer to request some medical documentation to substantiate the employee's need to take that leave. And typically that's a simple doctor's note to say this person needs this many days off, or needs to be off sick because they're ill. It doesn't often include much detail. When it's a more complex medical need or medical situation, and the employee needs to take more time, that's when it becomes more reasonable for the employer to get more information about the specific medical restrictions and limitations of that employee, to understand what the most suitable accommodation for that employee is and how they can go about facilitating that. The employer is not entitled to know the specific diagnosis in order to protect employees' privacy, but they are entitled to know the limitations and restrictions that occur, that the employee's physical or mental illness place on their ability to do their job. You're also entitled to know their prognosis for recovery and expected timeline for their return to work, although often that can be very difficult to predict, as we know with illness and temporary disabilities. It's not a formulaic exercise, but through the whole process of requesting medical information and accommodation is very important. I can't say this enough times, to document. Make sure that you're documenting your requests for information, you're documenting the person's responses and documents that they're providing to you. Obviously, that needs to be kept confidential and private, but do make sure you keep a record so that if issues arise down the road, you have that. And Tiffany will talk a little bit more about some of what those issues might be and how you might be able to address them.
Yeah, that's a great point, Evelyn. You do always want to document it as you go, for sure. We had a good question come through in the chat asking, if an employee makes no accommodation request, does an employer need to have a tactful conversation about a possible accommodation if there is reasonable cause? So that's a good question and one that comes up a lot for employers, and it's a tricky situation. Process of accommodation really begins with a bona fide request from the employee to be accommodated. However, if you are in the employment context and you're noticing changes with your employee, best thing you can do is have a conversation, make it a gentle one and let them know you're here for them if they need assistance. Offer up the EAP program if you have one at work. Let them know that you're open for dialogue, because sometimes, these things can be tricky for employees to navigate, especially when you look at things like mental health. And so letting them know that you're open to the conversation is always a good starting point while balancing their privacy. So moving on, now that Evelyn has really laid out the foundations of the sorts of medical information you can seek and your duty to accommodate the employee, let's talk about a couple of complex statuses that can occur as a result of an employee being on leave. So frustration of contract can effectively bring the employment relationship to an end. So frustration is a general contract principle which can apply to the employment contract or to the employment relationship. It's really a relatively rare occurrence, and it can be very difficult for an employer to prove frustration of contract. So when the employer and employee enter into a contract or employment relationship, and an unexpected event like the health, the disability, or the long-term disability of an employee makes further performance of the contract radically different from what the parties agreed to, for example, because the employee can no longer actually work for the employer, and the instance is not considered the fault of either party, and it is not anticipated by the contract, then a court may conclude that the contract has been frustrated. So again, it's going to be a status that makes the performance of the contract radically different from what was entered into. It's not anticipated by either party. And it's not anyone's fault, then it may be considered frustration. Frustration is only going to be found to occur when there's no reasonable prospect that the employee can return to work. Whether frustration has occurred is really going to depend on the anticipated duration of incapacity, the duration of the employment, and the nature of work to be performed. So like Evelyn has said throughout the presentation, again, an extremely fact-dependent situation that's really going to depend on what the medical note says in terms of the anticipated duration of incapacity, the expected duration of employment, and what kind of work is being performed. An employer should not terminate employment based on frustration without firm and conclusive medical evidence regarding the employee's potential for recovery. If you're going to raise this as a defense to terminating an employee, you really are going to need to establish that the employee's incapacity is permanent or otherwise shows no indication of allowing the employee to return to work in a reasonable amount of time. If you have to get all the way to court, what a judge is going to look at is the terms of the contract, including any sick pay, disability pay, or benefits, how long an employment position would have lasted without the illness, the nature of the employment, and the nature of illness, including the length and prospect of recovery and period of past employment. Let's talk a little a little bit about how the effect of a long-term disability benefit impacts the doctrine of frustration. So again, spoiler alert, it really depends on the facts of the case and the terms of the benefit policy itself. The mere existence of an LTD benefit policy or the actual receipt of LTD by the employee does not prevent the application of frustration from being applied. But the presence of long-term sick leave and disability benefits does indicate that a court would expect a greater tolerance for the duration of an employee's absence before frustration occurs. Meaning, where you have an employee receiving LTD, they're going to expect a longer runway of tolerance on your behalf before they're going to determine that frustration has occurred. Frustration is more readily applied where the LTD benefit policy or contract is really between the employee and the third-party insurer and expressly contemplates the continued benefit payment after employment has ended, meaning where the employer can really exit the relationship between themselves and the employee, and the LTD is going to continue, then frustration is going to be more readily applied. So why is claiming frustration rare? So some instances of frustration are quite obvious. These are cases of illness or injury that are profound and permanent, such that there's no realistic possibility of a return to work. Disputes over the application of the doctrine of frustration are more likely to arise and dicier for employers where an employer's functional abilities or prognosis are unknown and the medical is therefore a little bit unclear. So why are they so rare and why are they so hard to prove? Because the onus is on the employer to prove frustration, which includes providing medical evidence that illustrates that an employee is unlikely to return to work in the reasonably foreseeable future. Sometimes employers confuse this onus because they focus on the employee's failure to provide medical evidence of their ability to return to work. But that's not what the doctrine of frustration focuses on. The focus is on medical evidence which clearly shows that there's no reasonable prospect of the employee returning in the reasonable foreseeable future. So you want to keep that in mind. You're not going to be able to focus on the employee not providing evidence that shows that they're unlikely to return to work. It's going to be about that medical that concretely shows that they're not going to be able to return to work in the reasonably foreseeable future. The best that you can do if the medical is unclear is assertively follow up. Again, it's extremely fact specific, and I'll give you a very easy example. Sometimes in court, frustration is found after 8 months because the medical made it clear that the return to work is unlikely for 3 years. And then in other cases, frustration isn't found following an absence of 5 years because the medical didn't illustrate that a return wasn't possible in the near future. The last thing to just keep in mind with regards to frustration is if you are going to terminate on the basis of frustration here in Ontario for injury and illness, minimum standards as set out in the Employment Standards Act are still owed. So now that we've talked about frustration, let's turn to a different complex status, which is job abandonment. So frustration is really about a contract not being able to be performed due to an unforeseen event and an unreasonable prospect of the employee returning to work due to medical issues or disability, whereas job abandonment is really about the actions and intentions of an employee in respect of a performance of their job. So when an employee is absent from work without authorization or explanation, the employer may be able to treat employment as at an end. Whether doing so is defensible really depends on a properly built case of job abandonment. Typically, job abandonment will involve unauthorized or unexplained employee absences, and you may likely encounter one where an employee has left work, they have an illness or injury, but they haven't maintained contact with the employer to explain continuing absence. Where the employee persistently refuses to attend work or to explain their absence either themselves or through medical documentation, abandonment is asserted by an employer to end the employment. It's treated like a resignation without the express "I quit" statement. And because the employee is treated as the party ending the employment, the employer doesn't owe notice, pay in lieu of notice, severance pay, any of those things, unless that's expressly contemplated in the resignation section of their contract. So the test for job abandonment is very similar to that of resignation. The statements or actions of the employee, when viewed objectively by a reasonable person, must clearly and unequivocally indicate an intention to no longer be bound by the employment contract. So again, there's not usually this express "I quit" statement. So a defensible case of abandonment really relies on circumstantial evidence. And this often will involve the employer assembling several employee actions or statements that indicate the employee does not intend to return to work or otherwise meet essential job duties, which usually includes things like failure to report to work without justification. This is especially true where the absence is lengthy and where the employee has ignored repeated warnings from the employer that a failure to attend work or otherwise justified absence will be treated as abandonment. But it also involves those situations where you have a clear workplace policy or procedure about submitting proper documentation to justify the absence, and the employee is not following that either. Again, these indicators are always going to be assessed on the facts of the case. I'll give you an example of where abandonment has been found here in Ontario. One case where an employee had consistently failed over the period of 8 months to provide required documentation or attend necessary meetings about their accommodation and assessing the possibility of their return to work. And what the employer did right in that case was really emphasize in several communications that the failure to participate in the return to work process would result in abandonment. So where is job abandonment unlikely to be found? So it's not going to be found in a brief absence, whether it is explained or unexplained. So a few days is unlikely to, get you to job abandonment. It's also not going to be found where the silence of an employee is met with silence from the employer. So what I mean here is don't meet their silence with silence. Keep following up, asking them about their absence, keep following up and reminding them about their obligations to provide documentation, as well as remind them that this could lead to a finding of job abandonment. So abandonment often comes up in cases involving a medical or disability-related issue, and it often intersects with an employee's need for accommodation. So you do want to treat this carefully and tread lightly. Where an absence is related to a protected ground like disability, the employer really has to do everything in their power to accommodate the employee. So you need to assess the reason for the absence and take all reasonable steps short of undue hardship to get that person back to work. Now, practically, what employers often end up encountering, which can feel super frustrating for them, is they send out a lot of documentation, letters asking for more information, and they're met with an employee who just simply doesn't want to participate in the process of accommodation. When you have that kind of situation, you need to provide them extensive opportunity for the employee to participate before deeming the job to be abandoned. You need to remain sensitive to the possibility that their disability could really be impacting their ability to actually participate in the accommodation process. And if you don't, and you don't take all reasonable steps to engage the employee, you're really going to undermine your abandonment defense. So eventually, though, after repeated efforts to engage the employee and just being met with silence or not getting the documentation you need, then you may be able to successfully assert that the job has been abandoned. I'm just going to give you some quick practical tips about job abandonment. So when an employee is absent for a prolonged period without explanation, you really need to try to understand the employee's intentions before asserting the employee has abandoned their job. So don't open up with, hey, we assume you've abandoned your job. What you really want to try to do is understand why they're away. Is it a medical issue? Try to get that medical documentation without seeking the prognosis. Understand what's going on. You need to contact the employee, and if that fails, you have to try again. best to follow up in letters if you can, and go ahead and cite the times that you followed up in the past. You always want to include in these letters a clear date. So asking them to follow up on a date, asking them to provide medical documentation by a reasonable deadline. And you really want to indicate in these letters as well that a failure to follow the process as set out in the letter will result in the employer treating employment as abandoned. And then finally, once you've taken all these steps and you've documented it and you've saved all this documentation, you can assert abandonment. So we're quickly coming to our close here, so I'm going to turn it over to Evelyn just to talk about some of the key takeaways of today's presentation.
Thanks, Tiffany. So we've covered a lot of ground today. As we mentioned, these are complex issues which are often very fact-specific. So we tried to highlight the basic principles that apply to these situations. And the things that we really want you to take away from the presentation are that employers must accommodate medically based employee absences to the point of undue hardship, where undue hardship is determined by health and safety considerations and cost. It's a high bar. And if there's no reasonable prospect of a return after an employee is on an extended absence, based on a medical prognosis that you've been provided by their medical treating physician, then an employee may be able to terminate based on frustration of contract. However, again, it's a very high onus on the employer to demonstrate that an employee is not going to be able to return to work in the reasonably foreseeable future. The onus is high for employers when it comes to frustration of contract and also to prove job abandonment. As Tiffany just talked about, you need to try again, document everything as you go along before you can start considering asserting job abandonment or frustration of contract. And employees are required to participate in the accommodation process and to provide the required medical documentation to support their absences. And if employees are not participating and are essentially ignoring requests for medical documentation, etc., and remain off work, eventually that may also support a job abandonment claim or defense. And finally, as you hear us say often in our webinars, it is of utmost importance to document everything as you go through these accommodation and leaves processes. So unfortunately, we're already over time for our webinar today, and I know we do have a couple of questions left in the chat. If you'd like answers to those, please feel free to follow up with us afterwards. If you have any questions about specific situations in your own workplaces, please feel free to get in touch with us. We would be happy to help. Thanks very much for attending the webinar today, and take care.